Further hearing in the appeal, the Commissioners for Majesty's Revenue and Customs against DCC Holdings.
Mr. Furness.
Lord, a couple of points left over from yesterday, if I may, before I resume my submissions. The first is the letter of intervention from the Chartered Institute of Taxation. Your Lordship
Yes,
should have been given copies of that.
I actually retrieved this from our files yesterday evening. It doesn't take us very far, I don't think.
Lord, I have no comment to make upon it unless your Lordships have any questions about it.
I don't think so. Thank you. Thank you very much, anyway, for producing it.
The other point which your Lordship raised with me yesterday, which I didn't deal with, was your Lordships were interested in seeing the amended version of Section 97 with the retrospective amendment designed to cure the problem which arises in this case on DCC's construction. And your Lordship should have a print of Section 97 as it was before it was itself repealed as part of the tax rewrite. That's why it's in italics, because it actually no longer exists in its current form. But the amendment which is designed to cure the problem raised by this case is it's at the end of subsection 2. Your Lordship will see where a company has a relationship to which this section applies. And your Lordship will see A, 1 and 2, and then the words below B, subject to paragraphs A, 2 above, references to the corporation tax to a loan relationship accordingly include a reference to a relationship to which this section applies. Those are the words which were added to bring paragraph 13 of Schedule 15 into play. Your Lordships will remember my learned friend devoted some of his submissions to paragraph 13, which is the anti-avoidance provision.
Yes.
And he speculated, and I think your Lordship speculated, on why the Revenue didn't seek to rely on paragraph 13 in this case. And the principal reason was, as I'm instructed, that without those words, it was far from clear that Section 97 actually created a loan relationship, as opposed to deeming the manufactured payment to be interest on a loan relationship. And so those words were introduced to make it clear, as my learned friend showed in the explanatory notes, that the Section 97 loan relationship could be a loan relationship for the purposes of paragraph 13. Anyway, that's that amendment. And then the following words are the corrective amendment, as it were, and your Lordship will see that the way that the Revenue have approached this is to provide that the credits and debits to be brought into account in respect of manufactured interest for any period are those that are recognised in determining the company's profit or loss for the period in accordance with generally accepted accounting principles, but subject to the provisions of this chapter. So essentially the mechanism that's been adopted is to address the deduction point. Yes. By saying that you won't get a deduction unless your statutory profit and loss account shows that you've taken one on normal accounting principles.
Yeah.
Could I just ask a very elementary question, of which I ought to know the answer? What was the mischief which 737 and Section 97 were designed to deal with?
Well, 737A, which is the provision about
Yes.
manufactured payments, was designed to ensure that if you received a payment of interest, let's say on bonds or gilts, which you were contractually bound to pay over to somebody else, that you were deemed to make an annual payment of the same amount, so that you had to deduct tax from the amount as it was transmitted through. That's what Schedule 23A was about.
Yes.
And Section 97 is essentially performing a similar function within...
So without them, what would have happened without them?
Well, without Section 737A, my Lord, I suppose you could have situations in which a party in DCC's position could receive a coupon on gilts, but transmit it on to another UK taxpayer as part of a capital payment, which wouldn't then involve them making a deduction of tax. One can imagine circumstances in which you could structure a transaction to do that.
Yes.
So it's essentially ensuring that in, for example, repo transactions, that element of the repo which really represented the coupon being passed on was deemed to be an annual payment, so you could then ensure that there was an obligation to deduct tax. And then Section 97 is intended to perform a similar function within the loan relationship legislation. There isn't an issue about tax deduction at this point, because nothing in Section 97 requires you to deduct any tax. But Section 97 is essentially there to ensure that when you make a manufactured payment on, or would be deemed to make a manufactured payment on, that you get a deduction for that in your loan relationship computations. I mean, clearly it is there, so far as the DCC company is concerned, to give a deduction. We don't shrink from
now,
that. Now,
again, if it weren't there, what would be the position?
Well, if it weren't there, there might, well, as far as DCC is concerned, there might be a risk that it would take in a credit for the coupon, but not have the opportunity of making a deduction, because without this provision, the onward payment, the manufactured payment, wouldn't actually be interest, and you wouldn't be able to make a deduction from it because it wouldn't arise under a loan relationship. You can only make a deduction in your Section 97 computations for interest on loan relationships, which are defined as debtor-creditor relationships. Without this section, a manufactured payment wouldn't be interest on a loan relationship, so you wouldn't have any possibility of deducting it. So that in my submission, is the evident thinking behind Section 97. And it fits in also with the treatment of the ex-bank company, who is treated under 97(2)(b) as actually receiving interest on the original securities. So the idea is that although the coupon passes from the consolidated fund to DCC to ex-bank, ex-bank is treated as if it was receiving a coupon on the gilts directly. DCC is given a deduction to match the credit, as we would say, that it might have to take in respect to the coupon. Now, the problem we have here, the problem the revenue have here, is that on normal accounting principles, we accept that you wouldn't take a credit for the coupon, and therefore, if you take Section 97 as simply giving you a freestanding deduction, the revenue or Parliament rather, has conferred on the taxpayer a deduction in excess of what the taxpayer really needs. And it's then a question of whether or not, on our primary case, we can, on a construction of Section 84, say that the fact that Section 97 does, as I think Lord Hope said yesterday, seem rather generous on its face, doesn't matter, because the draftsman is clearly contemplating that to the extent that Section 97 might give a deduction that isn't needed, it will come out in the wash, as it were, when you take it together with the coupon.
But you need Section 84 for that.
You need Section 84 for that, Lord, yes.
If, just to pursue, if I might, Lord Collins's question a little further, let's assume that DCC didn't, this is without Section 97, didn't take credit. The revenue, what would the revenue do? I mean, is there a provision that you can identify in which you could have challenged their presentation of their accounts and said, look, you're obliged to take a credit because the legislation tells you so?
Sorry, Lord. So DCC doesn't take any credit.
Yes.
In its statutory accounts, yes, for well, that is in fact the position. They didn't take a credit for the coupon. Mm-hmm. And so what we're saying is that although we accept on our primary case that they're entitled to a deduction under Section 97, it's Section 84 again, yeah, which enables us to say, well, you must take a credit in your loan relationship computation, although not in your statutory accounts.
I don't think that quite meets my point.
Sorry,
obviously, you're concerned now because having not taken a credit, they can identify a debit in, yeah, the legislation. But the question I thought you were being asked to address is, let's assume the debit provision isn't there.
I'm sorry, Lord, yes.
And there's a credit which you would want to bring into tax in some way. And at the moment, I'm unclear how you could do that.
Well, Lord, if on normal accounting principles, it's right that DCC should accrue some part of the coupon,
Yes.
then that will be a credit on its loan relationships, regardless of Section 97. There may not be an onward deduction to make.
Well, that would get you to the 2.9 figure, would it, on the accruals basis?
Well, one could imagine a situation in which it would be appropriate for DCC to accrue £2.9 million of interest. Not, we would say, in a repo situation, but if they were just buying and selling the gilts in the market, they might accrue £2.9 million worth of interest. And they would simply take on an accruals basis, accrue that as a credit in their loan relationship computation, because on an authorised accruals basis, that is the right sum that they should accrue, and they would take that into account in their statutory accounts, and it would also come into their loan relationship computation.
But how do you, could you get up to the 28.8 figure?
Well, my lord, in that situation, we wouldn't need to, if we're positing that there is no Section 97 to give them a deduction.
Right. Yes, well, I think I understand that. Thank you very much. Yes.
Coming back to Section 97, your lordships will see at the top of the next page, footnote 7 explains the introduction of the words which appear at the end of subsection 2.
Sorry, I beg your pardon, I missed what you were going to know.
I was just going to finish off looking at the amended Section 97 to look at footnote 7 at the top of the second page of the print your lordships have, where it says that in subsection 2, words inserted by FA 2009, section 61, schedule 30, paragraph 5.2, with effect in relation to manufactured interest whenever paid, apart from payments treated under ICTA 737A5 as made before 27th January 2009. So that's the retrospective element, that there is a fully retrospective effect for this amendment, except where the manufactured payment is deemed. So in other words, what Parliament has done is carved out the facts of this case, recognising, of course, that it would not be appropriate to introduce legislation to try and change the potential result of litigation already in progress. So the category of cases on all fours with this case, which are deemed manufactured payments, are cut out of the retrospective effect. But cases involving actual manufactured payments, which are not on all fours quite with this case, are made subject to fully retrospective legislation.
It's been suggested to me it would be helpful to have just a note in writing of your answer to Lord Collins's point. Let's assume that Section 97 wasn't there, how the matter would have been dealt with.
Yes, to flesh it out, really, I suppose it's fairly obvious for 730 and 737, but what do you say is the mischief these provisions were intended to deal with, and what would be the position if they weren't there?
So it's Section 97 and Section 737.
Yes, but
what is their mischief?
Yes, I mean, it would be helpful to me at any rate if you do the same exercise, although it's probably much easier, with 730A and 7379 and 84.1.
My Lord, I'm sure we can do that certainly by the end of the week if that's convenient.
Thank you very much.
My Lords, what I intended to do now was take your Lordships fairly shortly through our alternative submissions and then pick up about 3 points on the Learned Friends submissions from the day before yesterday, and then, subject to any points that your Lordships, other points your Lordships may have, I'm done. Our alternative submissions are at paragraph 56 of our case, which your Lordships may find convenient to turn up in the core volume. As your Lordships will appreciate, I've advanced our primary case on the basis that we accept that if you look at Section 97 on its own, the most plausible construction of Section 97 is that it is intended to give DCC a deduction of 28.8 million. On the assumption, essentially, that the interest accrues, the whole of that interest accrues over the period of the repo, which is the assumption that Mr. Holgate makes in his report. But we say that that construction of Section 97 creates no absurdity if we are right about Section 84. But then the question arises, well, what if we're wrong about Section 84?
Well, so you can cancel it out.
Because we can cancel it out, yes. But what if we're wrong about Section 84? What if my learned friend is right, that really the court has no choice but to construe these three loan relationships which are an issue by themselves and take the appropriate credits and debits, including 2.9 million for the gilts? What if my learned friend is right about that? Well, of course, if he's right about that, then if Section 97 gives a full deduction of 28.8 million, you end up with a commercially absurd result. And in a way, this is where the absurdity authorities come in, because we would say that if the court is faced with that conclusion, if the court is faced with a situation in which even Lord Justice Rymer recognised would be commercial insanity, then that does justify taking a second and rather harder look at Section 97 to see if there isn't a construction of Section 97 which is fairly open on the words and which would avoid the absurdity. And we say there is a construction which avoids that absurdity because giving the full deduction of 28.8 million involves accepting Mr. Holgate's assumption that the whole of the interest, or the whole of the 28.8 million, accrued over the period of the repo, over the 15 days. But that is an assumption, as he makes very clear in his report. If your Lordship turns up at paragraph 723, appendix part 2, it's on page 237. Your Lordships will recall, I showed you this yesterday, at 722, he says it's not possible from an accounting perspective to determine the debits and credits to be brought into account under Section 97 as it stands without making some assumptions, because as an accountant he's not told enough about the deemed loan relationship to do that. And then 723 he says, if there is a legislative need to determine the debits and credits to be brought into account, I would understand the legislation may be making an assumption that the deemed interest was payable in respect of a period for which DCC was a party to that loan relationship. And as I've said, on our primary case, we accept that's a perfectly reasonable assumption to make about the way that Section 97 was to work. But if you're against us on Section 84 and you're faced, therefore, with a wholly absurd result, it is, in my submission, perfectly open for the court to say, well, we could make some other assumption about the accrual of interest under Section 97. And in particular, we could assume that although DCC is a party to the loan relationship for only 15 days and accrues a liability for 15 days, that you accrue the interest on the loan relationship over the period of the coupon. And if you do that, you end up with a 2.9 million debit, which equates to the 2.9 million credit, which Mr. Holgate or DCC is taking in respect of the coupon. So in respect of the coupon, DCC are saying, well, the coupon accrues over the whole period of 6 months, but we only owned it for the gilts for 15 days, so we only accrue 2.9 million. And we are saying, well, granted that the Section 97 interest arises out of a payment which is representative of the coupon, why should one not accrue the Section 97 interest over the same period as you're accruing the coupon interest, 6 months, but assume, as Mr. Holgate does, that DCC is only party to that loan relationship for 15 days, and accrue a 15-day liability of 2.9 million.
Where
It is
do you
not.
find-
Sorry.
I was just wondering where you find the basis for that in the language of either 737A or 97. What words are we construing to achieve?
Well,
which are-
what you're doing, my lord, is looking at section 97 and seeing that gives you, for loan relationship purposes, sorry, does your lord just want to turn it up again? It's the key words are 97.2a. In relation to that company, that includes both DCC and X-Bank, but we're interested in DCC. In relation to DCC, the manufactured interest shall be treated for the purposes of this chapter as if it were interest under a loan relationship to which the company is a party. So that's the key wording. And we're then told that we have to apply an authorised accruals basis of accounting to that interest. So it's not enough that there is a payment or even that there is interest under a loan relationship to which the company is party. You then have to decide how to accrue that interest, and in particular whether to accrue all of it or only part of it. Now, the assumption that Mr. Holgate makes and that DCC makes is that it was by implication, Section 97 is suggesting you accrue all of the interest. In other words, you assume that the interest accrues over the same period as DCC is party to the loan relationship. So you end up, it's interest of 28.8 million on 15 days, and therefore you accrue the whole of the 28.8 million. But there's nothing in Section 97.1 that expressly tells you that. That's simply an assumption you have to make, as Mr. Holgate explains, in order to to derive an accounting treatment for that interest. So my learned friend can't point to any express words that say that the loan relationship is deemed to be coextensive with the period of the repo, and therefore you accrue all of the interest. I accept it's probably what the section is driving at, construed in isolation. That's the most likely construction. But if you find that the section is actually, as a result of that, producing a wholly bizarre and absurd result, you're entitled to say, well, is it the only assumption I could make? Now, I cannot point to express words that say you must accrue the interest over the whole of the period of the coupon, and only accrue in respect of DCC 15 days worth. But neither can my learned friend point to any express words that say that you accrue the interest over the period of the repo and not the period of the coupon. It's a question of what assumption you make in order to give the section some effect.
What is the figure that's identified by Section 97.1a?
Section 97.1a identifies the sum of 28.8 million, yes.
So that is the manufactured interest?
Yes.
Which one then carries forward into subsection 2?
Yes.
So your approach, as I think you were just saying, actually has to be found in 2A.
Yes. It's the question of how you apply an authorised accounting method to the interest which is deemed to be payable as a result of 2A, yes.
2A plus, as Lord Clark said, 84. I mean, 84 is essential.
Yes.
You say, all right, well, maybe you start off with a figure of 28, but when you look at what it, you look at the substance of it, you find that only 2.9 is the right amount.
Well, look, it seems to us that if we're right about Section 84, then we can accept that 97.1 and 2 are intended to give a full deduction of 28.8 million, because we can then match it as a result of the Section 84 computation. Where we really have to rely on this fallback argument is if we're wrong about Section 84. If my learned friend is right that one takes one accounts for each loan relationship as a loan relationship in itself on its own, and ends up with an accrual of 2.9 million for the gilts, and he says a deduction of 28.8 for the Section 97 interest. Now, at that point, we say, well, that is a wholly absurd result.
And you say it's got to be symmetrical, really. That's the only approach that makes sense of it. And you don't particularly mind whether it's 28 against 28 or 2.9 against 2.9 or even 0 against 0, as the Special Commissioner thought.
Well, my Lord, indeed, the bottom line is that we don't mind. We have always thought it was incumbent upon us to say to the court, this is what we think the right answer is, and we think it's 28.8 to 28.8. We don't come to the court and say, well, there are three ways you could get to the answer you choose. I mean, we've nailed our colours to that mast. But that's because we think we're submitting we're right about Section 84. If we're wrong about Section 84, then in my submission we do end up with this absurd result, which does justify a second and rather harder look at Section 97 to see whether, even if we're wrong about Section 84 and it doesn't permit the sort of holistic treatment of the three loan relationships together that we're arguing for, nonetheless, one can reach a construction of Section 97 that avoids the absurdity of having a situation in which a coupon or payment of interest under the loan relationship, which is owned by DCC, is accrued on one basis, namely 15 days out of 6 months, whereas the manufactured interest, which represents the onward transmission, is accrued on a wholly different basis, namely 15 days out of 15 days.
The words "as if" at the beginning of little a are the fiction, aren't they? I mean, that is asking you to assume something that isn't a fact.
It isn't. It is, my Lord. It's not actually interest at all. A manufactured payment, as a matter of legal analysis, isn't interest. It's simply a contractual payment. And still less, of course, because we're dealing with a deemed manufactured payment, is the fact that DCC give credit to X-Bank on the repurchase price for the amount of the coupon. Clearly, that cannot be characterised as a payment of interest. So that's where the fiction comes in. Yes.
I mean, you can get some comfort, can you not, from 97(1)(b), that you're only into this at all if it's a payment which is representative of interest.
Yes, yeah.
And it's quite odd if a payment that is representative of interest that had accrued over 6 months is to be treated as if it had accrued over 18 days.
Well, that's so. And it's quite odd that where the onward transmission is, well, I think it's the same point that the Lordship is making, that where the onward transmission of the interest on the loan on the real loan relationship is accrued on a different basis to the basis on which the interest on the real loan relationship is accrued.
On your alternative, on the 2.9 argument, what part does Section 84 play?
Well, my Lord, at this point, I'm assuming my learned friend is right about Section 84, that it has actually a relatively limited role compared with what we would assign to it. That Section 84 is really simply there to assist in, it's an instruction to add up the credits and debits that you arrive at by applying an appropriate accounting method to each of the loan relationships seriatim, and then you add them up under Section 84, and you don't take an overview, as it were, in the way that we suggest.
But if you are adding it up on a bit-by-bit basis, on the 2.9
Yes.
analysis, how does it work? How does the adding up work?
The adding up works, as my learned friend would have it, that he takes a credit of 2.9 for the coupon on the gilts, which is his accrual for the period of ownership. He takes a credit of 1.8 under Section 730A, which is the credit represents the profit on the repo, and he takes a debit of 28.8 under Section 97, because he says under Section 97 he is entitled to accrue the whole of that 28.8 payment, even though he's only accrued 2.9 for the coupon, which the 28.8 onward payment represents.
And your analysis?
And our analysis is, if he's right on his views of Section 84, that it has a more limited effect than we would contend for, that it's perfectly legitimate to ask of Section 97 whether or not it is right in those circumstances to assume that in every case under Section 97 you have to accrue all of the deemed interest payment simply over the period of the repo, or whether you can't accrue the interest under the deemed loan relationships in Section 97 over the same period as you've accrued the interest under the coupon, i.e. 6 months.
And then you get the 2.9 million instead of the 28.8
And then you get a 2.9 million instead of a 28.8.
Is it possible to look at it this way, that you've got your amount which is representative of interest, and you're then asked, or told rather, by subsection 2A to treat it as if it were interest under a loan relationship, and then you say, well, all right, you look at section 84, and you're told to apply an authorised accounting method, and you look at 85, which tells you a bit more about that, and the normal accountancy practice would be to accrue a given figure over the period during which the gilts were in the ownership of the party whose accounts you're looking at. I mean, is that
Well,
the line
no,
of
that's the Learned Friends approach to the coupon.
Yes.
And what we're saying is
You're saying apply the same approach
that you could apply the same approach. It would be legitimate to assume that Section 97 intended you to apply the same approach to the onward transmission of the coupon, to the sum which represents the coupon. Section 97 doesn't say so in terms, but neither does it say in terms that you accrue the onward transmission payment simply over the period of the repo to give you 28.8.
Could one say that, looking both at 97.1b and 2a, that nothing is said in either of those provisions about the period that you're looking at? So that's the question. I mean,
that's the question. I mean, and that's clearly one of the factors that makes it so difficult for Mr. Holgate, without making some assumptions, to decide how to accrue this interest. I mean, clearly you cannot begin an accruals basis without making some assumptions about the period in respect of which the interest is payable. And the section says nothing about that.
So you can make a different assumption in different classes of case.
Well, look,
there isn't any assumption which you have to make as a matter of construction of the section.
Well, my lord, I would say that in all on this basis of our case, that in all cases the correct approach to Section 97 is to apply the same basis of accrual to the interest under Section 97 as you have applied to the interest which it represents, i.e. the coupon. So if you apply a time-based accruals basis to the coupon, you do the same to the manufactured interest. So that I'm not saying that there's a particular construction for this case. What I'm saying is, in all cases, that it's a reasonable assumption to assume that Section 97 intended you to make the same basis of accrual on both sides of the transaction, as it were.
Because otherwise it gives an entirely unchecked debit.
Yes. Yes.
Which Parliament couldn't possibly have intended,
Lord,
especially
yes.
in a tax avoidance statute like this.
Well, in fairness, Lord, Section 97 isn't a tax, doesn't come under a tax avoidance rubric. I mean, Section 97 is, as I've suggested, probably intended to help the taxpayer in this respect, rather than to check avoidance. But,
well, 97.2b is not helping the taxpayer.
No, 97. It's a section which is intended to bring about a particular tax result, which, in my submission, is intended to correspond to economic reality. So it's not helping the taxpayer under 2b, but it is, in a sense, helping the taxpayer in respect of the deduction that it can make under 2a.
Could you make the same argument in relation to 97.2b? Because you're simply told there that the manufactured interest is payable as if that relationship was the one under which the real interest is payable. I mean, on the language, it's rather more difficult to say that one doesn't take the whole of the 28.8.
Well, once you're looking at the party in the position of X-Bank, then obviously you're looking at the appropriate accounting treatment for that payment in X-Bank's hands.
Yes.
And that may or may not be the same as the appropriate accounting treatment in the hands of DCC. One would have to form a view about X-Bank's position. So I'm not sure that I would accept there's a necessary corollary between the two, because there is a different hypothesis. 2B is imposing an additional hypothesis, as your lordship has pointed out, namely that you're assuming that the interest is actually received under the gilts rather than
And it's
under the
aimed at a
contractual
different target to some extent, isn't it? Because if the holder is non-resident, then it's important that it should be treated as interest on gilts rather than other income from a UK source, isn't it?
Well, not, to that extent, where the holder is non-resident, it might well benefit the holder to have that position made clear. My lord, yes. So, my lord, that's what I wanted to say on our primary fallback argument. We do, and this is coming back to our case, paragraph 59 onwards, point out that naught and naught is a possible result, although it's very much a fallback on a fallback. We say it's a better result than DCC's contention. It seems to us, my lords, that apart from anything else, nobody is actually contending for an accrual of 0 in respect of the coupon. We're saying it should be 28.8, and Malone Fred is saying it should be 2.9. But if your lordships thought that the right answer was in fact 0, and the case for saying it's 0 is that that's the way it's actually treated under normal accounting practice, as Mr. Holgate explains, I think I would submit that this fallback only really arises if your lordships are with us on section 84. So in other words, I've persuaded you that section 84 does allow an adjustment of the entries to ensure that taken together, the end sum fairly represents, etc. But your lordships feel more comfortable in taking a nil credit than a 28.8 credit. I mean, Lord Clark taxed me a couple of times yesterday with the fact that 28.8 is not per se something which an authorised accounting method would attribute to the coupon. It's either 0 or 2.9, and we accept that looking at the coupon in isolation, an authorised accounting method wouldn't produce 28.8. So your lordships might say, well, maybe it would be better to take 0 in rather than 28.8. But again, applying a purposive construction of section 97, we would say that if you're taking 0 into account in respect of the coupon, and you're then asking, well, what on an authorised accruals basis should one accrue in respect of the onward transmission? It's the same point again. If you're taking 0 in respect of the coupon, then you should accrue 0 in respect of the onward transmission. But that's, as I say, it's an argument your lordships probably only need to consider. Well, certainly only need to consider if you're against us on both of our prior arguments. And I suspect if you're against us on both of our prior arguments, this argument on its own is not likely to get us home. But as I say, if your lordships were with us on section 84 but felt some reluctance to take in 28.8 because there was no accountancy basis for doing so, looking at that gilts holding in isolation, then 0 and 0 would be an appropriate way forward.
Yes.
So, Lord, that's all I wanted to say on our arguments. Sorry, I'm a little over my promised half an hour, but there were just, I think, three points I wanted to pick up on my learned friend's case and arguments, and none of them are, in my submission, particularly go really to the heart of the argument, so I can deal with them quite quickly. My learned friend said a certain amount about the purpose behind the introduction of Section 730A, and he said that its purpose was to create fictional streams of income so that they could be taxed. And of course it does create fictional streams of income, both so that they can be taxed and both so as to ensure that, certainly in the case of 737A, that withholding tax is indeed withheld. But as far as Section 730A is concerned, I just wanted to put on record that we don't accept that it was simply the crude revenue-raising exercise that my learned friend would have you believe. There is another view, which is the view of, at the time, published by the Treasury and the Revenue. And the material on that, I'm not going to show it to your lordships now, but it's there if you wish to read it, is in the Revenue Skeleton before the Special Commissioner, Volume 2, page 298. In which we explain that, in fact, so far as the Treasury and the Revenue are concerned, although not my learned friend, the actual reason for the introduction of 730A was to facilitate a market in gilt repos. Because prior to the introduction of 730A, the only participants in the gilt repo market had been traders who were authorised to trade in gilt repos. They were all traders. And the idea was that the market would be opened up to non-financial traders. But one of the problems with that was that for non-financial traders who had gilts but wished to borrow money against them, they would need to be able to claim an interest deduction in respect of the liability they incurred under the repo. And 730A not only creates a fictional stream of income to tax, certainly it does that, but it also creates a fictional stream of interest which can represent a deduction. And it was thought that that was an important element in the introduction of Section 730A, that you should have, that for non-traders participating in the market, they should be able to claim a deduction for their interest as well as being taxed on any interest that they accrue on the other side of a repo.
So 730 wasn't simply designed to go behind the form and tax the substance?
Of course it does go behind the form, my lord, but if one is talking, as my learned friend was, almost about the motive for the introduction of 730A, there is more to be said for it than simply, as my learned friend would have it, a crude revenue-raising exercise. I'm not going to say any more about that. When I made these submissions, I think before the Special Commissioner or the Judge, I can't remember which it was, my learned friend accused me of being sanctimonious. I think on the basis that he had difficulty accepting that revenue legislation could have any social or economic purpose beyond the raising of money. But there we are. I just wanted to, as it were, from our point of view, set the record straight. Your Lordship can see we've quoted from the material and the press releases which back that up. But it doesn't, at the end of the day, I think, assist your Lordships one way or the other on what the right answer is. Paragraph 13 of schedule. So moving on to the next isolated point on my learned friend's submissions, he placed a little emphasis on paragraph 13 of Schedule 9, which is the targeted anti-avoidance provision. And I've explained to your Lordships already this morning that the reason it wasn't invoked is that under Section 97, as it was at the time that DCC's transactions went through, it was far from clear that that Section 97 actually created a deemed loan relationship for the purpose of the legislation, as opposed to deeming the manufactured payment to be interest on a loan relationship. And there were also, as I understand it, issues about whether or not, in any event, it could be shown that these transactions had been entered into with a predominantly tax avoidance purpose, because they are, after all, perfectly straightforward commercial transactions. And whether DCC would have admitted that they had a tax avoidance purpose if they had been taxed with it, who knows. But anyway, for whatever reason, paragraph 13 wasn't invoked. But in my submission, the existence of paragraph 13 doesn't assist my learned friend in his construction of section 84. He was inclined to say that, in a sense, paragraph 13 should be regarded as the only element of the only extent to which Parliament is concerned to deal with tax avoidance, and that therefore one shouldn't worry too much. I understand this was the gist of what he was saying, that one shouldn't worry too much that Section 84 and Section 97 produced tax avoidance possibilities because Parliament had enacted this targeted provision. But we say that the fact there is a targeted anti-avoidance provision doesn't mean that this court has to abandon any attempt to reach a sensible and purposive construction of the main provisions which actually generate the charged tax in this case. And we say that the existence of paragraph 13 is frankly neither here nor there when it comes to deciding what Section 97 and Section 84 actually mean. And the other point he made was, well, that this is the result that he contends for is simply what happens when you have a mismatch between two statutory regimes, where you have where you have the ICTA regime, 730A and 737A, coming up against a new loan relationship regime. And my learned friend is saying, well, you shouldn't be too surprised if Parliament attempts to, as it were, put together two sets of legislation which have different origins and perhaps are looking in slightly different directions. It sometimes happens that when two pieces of legislation are married together, some unexpected results will eventuate. And he refers to the Darcy case, which is a decision of Mr. Justice Henderson, in which that indeed occurred. That was a case about the interaction between what's called the accrued income legislation and repos. The accrued income legislation applies to individuals who take out repos, but not anymore to companies now that they're dealt with under loan relationships. And Mr. Justice Henderson said, well, yes, it does sometimes happen that two sets of legislation don't quite dovetail. That was a specific and intentional tax avoidance scheme case where the taxpayer had deliberately targeted a particular mismatch. But what we're saying here is, of course, it's possible that there has been a mismatch. It's always a possibility. If my learned friend is right, that indeed seems to be what has happened. But one should be reluctant to conclude that there is simply a mismatch here, where one is looking at transactions which were clearly, i.e. repos, which are clearly within the ambit of the loan relationship legislation, which the draftsman has clearly taken some trouble to try and match up with the ICTA legislation, section 730A and 737A. Of course it's possible that the legislation has gone wrong and that the draftsman and Parliament have not quite married the two together properly. But the court should be particularly reluctant to reach that conclusion in a case like this, where, as Lord Justice Moses pointed out, if this legislation doesn't work for these transactions, this is a major failure. It's not the legislation has misfired, but as he put it, the charge has exploded in the barrel. Because if my learned friend is right, then all repos, not just this sort of repo, but all repos of gilts and bonds, have been mistaxed or should have been taxed on a basis which in no way corresponds to the true accounting profit on those transactions. And this legislation will have been a complete failure so far as it relates to repos. So those are the only other points, subject to anything anyone else sitting around me wishes to remind me of, that I wanted to take up on the learned friend submissions, unless there are any other issues your lordships wish to raise with me.
No, I don't think so, Mr. Furness. Thank you very much indeed. Mr. Gibbon, do you want to add anything? Thank you. Well, Mr. Gardner.
I'll try, my lord, to take the various points that my learned friend has raised in the order in which he raised them. So I'll deal with the points that he dealt with yesterday first. He raised a lot of points, and I've actually numbered them in my submissions. I'm not sure that's necessarily going to be helpful, but I do actually have a short riposte. I think you might be glad to hear for each of them. The first point he touched on, as I understood what he was saying, was that he accepts that in these kinds of cases, repo with a coupon paid in the repo period, that had the legislation simply been section 730A extended by 737C subsection 9, then that would have arrived at what was required under his submissions, being the taxation of the economic profit. So he accepts that. It therefore seems to me that what one's got to do, and I'll come to this, is look at what was the purpose of the other provisions giving rise to supposedly additional credits and debits. It cannot be justified by an argument of purpose related to achieving the economic profit in the accounts. And then the second point, and I think perhaps this is the most substantive point on his primary argument, is that he contends that looking at everything together, you are required as a matter of accounting to come back to a result that is a true and fair view of the transactions recorded in the statutory accounts. And that, as I understand it, is the heart of his primary case. And in my respectful submission, that is to mistake the terms and purpose of the statutory provisions. Under those terms, the starting point is not the statutory accounts. Under those terms, the starting point is 3 loan relationships as a matter of law. 1 actual loan relationship as a matter of law, the 18.5 days holding of the gilts. And I'm sure it was a slip of the tongue, my learned friend kept on referring to 15 days, but on the sample transaction is 18.5 days. Nothing turns on that, but I'm sure we're talking about the same thing. So 1 actual and 2 fictional loan relationships. And then you've got to apply to each of them an authorised accounting method, which is an accruals method. And that gives rise to 3 sums. As far as the gilts are concerned, 2.9 million. And the only other figure on an accruals basis could be 0. On Mr. Holgate's evidence, there is no conceivable way in which that figure could be 28.8 million on an accruals basis of accounting. That's the first figure. The second figure is the agreed figure of 1.8 million for the purposes of the loan relationship under section 730A. And the last figure is a debit of 28.8 million, which is the debit created by the fiction in section 97(2). And I'll come back to that in relation to my learned friend's alternative argument. And I didn't say anything seriously about this in opening because Sir Lordship's rightly suggested I could deal with it in reply. But at the moment I'm dealing with his primary argument. So those are the 3 figures which one brings in by applying an authorised accruals method to the 3 loan relationships recognised in the legislation. And that, in my respectful submission, is the process one has to adopt in consequence of section 84. And then one has to aggregate those sums. And it is those sums that fall to be aggregated. One has to look at them to see whether, taken together, they fairly represent the interest on each of those loan relationships. And I stress interest because in this case we are only concerned with interest. In my learned friend's submissions and his written case, he's constantly talking about profits and the profits in the statutory accounts. We are concerned with 3 lots of interest, 2 credit interests, the 2.9 or the 1.8, and 1 debit interest of 28.8. And his argument then goes on to say that in aggregating those 3 sums of interest, in effect, you have to discard all of them, or all of them but the 1.8 million. Because that's precisely what he's doing. He's not doing what you're required to do by the statutory provisions. What actually he's doing is simply replacing the statutory requirements and the accounting methods applied to the 3 loan relationships. He's replacing them by the accounting consequences of a different transaction.
If plural includes the singular. Why isn't that permissible under the wording of 84.1? Because that is the sum which fairly represents the interest.
It would be the sum which fairly represents all the interest under the three loan relationships, my lords.
Yes.
Yes. I'm sorry.
Why isn't Mr. Furness's solution possible if sum means, how is it not possible that Section 84.1 could apply simply to the 1.8 million if sums includes sum?
Yeah, because it's talking about all interest under the company's loan relationships. Therefore, one's talking about the totality of the company's loan relationships. And there are three of them. And therefore, shall be the sums, that is a total of three loan relationships, a total of three lots of interest. And it has to be the sum of those three lots of interest that one brings into account. And whichever way one looks at it, he's either bringing in the profit recognised in the statutory accounts in respect of a different, in substance recognised loan, or alternatively, he's simply bringing in the Section 730A amount of interest and not bringing into account the other two amounts.
I'm not sure it's...
And I'm not sure I necessarily understand your Lordship's question. I'm sorry.
Well, and perhaps I'm certainly not expressing it properly. Why cannot this, the 1.8 million be the sum which fairly represents, in accordance with authorised accounting methods, and when taken together it would be a problem, of course, but why cannot that sum be the 1.8 million which arises from all the loan relationships? Now, I do accept that when taken together is a problem because there has to be more than one.
Yes. Well, that I think is the point. I mean, that is predicating that it goes back to the definition. Section 81 defines a loan relationship in the singular. So for the purpose of this legislation, what 84 is doing is, as it were, the final process of aggregation. You've got to find, looking at the legislation, a loan relationship. Once you've found a loan relationship, you've then got to work out what is the interest, which what we're concerned with, under that loan relationship.
You've also got Section 84(1)(b), which says all interest.
That's right, my lord, yes. And that's the point that I was trying to make in a sense. We're only concerned with interest in this particular case. And all interest, in my respectful submission, must mean the total of the interests under the various loan relationships. So one starts by identifying a single loan relationship. You've then got to work out what the interest is under that single loan relationship. And then for the purposes of the computation in 84.1, you were told that what you bring into account in your computation, you've then got to spread it between trading and non-trading, if that's relevant, but forgetting that, shall be the sums which represent all interest under the company's loan relationships. And we've got three loan relationships, and therefore the sums will be the sums of those three figures that I've given, two positive and one negative.
You can get to 1.8 if you can have a plus 28.8 and a minus 28.8.
Yeah, well, that I accept.
Or a plus 2.9 and a minus 2.9.
Yeah. And as my learned friend says, any figures are all right for him, provided they actually knock each other out.
Quite.
I mean, that's what his argument comes back to. And I would suggest that actually is of some relevance, because that illustrates that his arguments on the figures, my Lord, I took on board what Lord Walker said about symmetry. His argument is on the figures, it's not on the words of the legislation. And also the problem, it does seem to me, with his argument is, he says you've got to regard the underlying reality, Well, as I said in opening in this case, had that been the basis of the legislation, as indeed it is after the Finance Act 2007, had that been the basis of the legislation, yes, of course. But what he's trying to do is to get back to a different form of legislation which has not been enacted in these particular provisions. He's trying to get back to what the Special Commissioner got back to, which is the results in the statutory accounts. And what it's doing is substituting, as the result of the exercise under the words of Section 84, the statutory accounting result for what actually is required as the process by the legislation. And as we say, that's simply not complying with the statutory precept, the words of the relevant provision. And we say that the error is exactly the same as in the judgment of Lord Justice Ricks, in paragraph 108. And certainly this argument doesn't, as we see it, seem to be the argument adopted by Lord Justice Moses. He's not ending up with the statutory accounting results. He manifestly can't accept, and one can see it if we look at his judgment, what the Special Commissioner decided. He brings it in from section 97. It's that paragraph I spent some time looking at the last sentence of yesterday in Lord Justice Moses' judgment. That the basis of his judgment, as I understand it, is paragraph 71. And he's looking there at one loan relationship, be the loan relationship of the gilts. He's not looking at an overall substitution by reference to the figure in the statutory accounts. He's there looking at the loan relationship constituted by the ownership for 18.5 days of the gilts, and looking at what he regards as the effect of the debit of 28.8 million under section 97. And he's then suggesting that that creates an additional credit under the gilts to bring the loan relationship under the gilts up to 28.8.
So are you reading from from paragraph 71? If you are, I'm lost. Or
I'm sorry,
you're evidently
yes, 71,
not.
the final 4 or 5 lines.
Last sentence, is it?
Yes. He's saying the effect of the application of accruals basis to the coupons is to deprive the deemed manufactured interest of its essential statutory function of cancelling out the credit payable to DCC. It produces a sum which, when taken together with the other sums, does not cancel out the credit, but exceeds it by a substantial margin. And in consequence of that, he comes to the conclusion that the amount to be brought into account in respect of the ownership of the gilts is 28.8 million, rather than his prima facie figure that he came to earlier on of 2.9 million. And I think that's clear from the next paragraph, my lord, in paragraph 72. He says to use the words of the section, the sum given by the application of an accruals basis as a credit deprives the deemed interest expense of its statutory function. That sum cannot be said, when taken together with all the credits and debits, fairly to represent all the interest under the loan relationships.
That's if you start with the 2.9.
Yes.
He says if you start with the 2.9,
Yeah.
then it doesn't fulfil its statutory function of cancelling it out. So in order to cancel it out, you have to have the 28.8.
That's right, my lord, and I'm sorry.
Now, is that the same point as is being made on the other side here?
Well, I didn't quite understand it, my lord, because the way in which my learned friend was putting it here was that taken together, you actually get back to the statutory accounts, to the figure of the statutory accounts. I mean, that's the way in which he put it, I mean, several times yesterday, and indeed, actually, I think this morning. Whereas what Lord Justice Moses' analysis is, as I understand it, is that because you brought in the debit of 28.8 You've then got to adjust your 2.9. Because he says that you've got a debit of 28.8, that is really thinking about a corresponding credit of 28.8, therefore you've got to bring in 28.8. That, as I read it, is his thinking, and I think it's absolutely plain from
So
the...
do you start with the credit or do you start with the debit? Wouldn't matter, perhaps.
Well, I think where he prior to paragraph 69, he's got to a situation whereby everybody has agreed 1.8 is section 730A. He said prima facie 2.9 is right for the interest on the gilts, and he's accepted that 28.8 is the debit under section 97(2).
Well, he's accepted that in paragraph 51, and he doesn't revisit it to whether it can live with some of his later conclusions.
Yeah, well, that's absolutely correct. But as a matter of analysis of his judgment, that is the correct position that he's in. And where he's in these paragraphs, 69 to the end, he is looking at the ownership of the gilts, the interest on the gilts. And he's saying that because you're bringing in a debit of 28.8, and the basis of that debit must have been to correspond to a credit of 28.8, then you must displace the credit of 2.9 with a credit of 28.8. And that's what he does, and it's clear at the end of the paragraph 73, the last sentence on page 20, he says, the construction of the relevant statutory provisions I have proposed does permit the conclusion the sum to be brought into account in respect of the coupons is not 2.9 million, but is 28.8 million.
And that's because his view is that the statutory purpose of section 97 was to give the taxpayer a debit to cancel out the credit.
Yes, that's right.
And you say he was wrong about that?
No, my lord, as I think I said yesterday, as far as the repo provisions that we're concerned with, 738 and 737A, and we're particularly concerned with 737A, prior to 1996, when the loan relationship provisions were enacted, they did actually work correctly. And the purpose, and I mean, this is really quite important to the case, and it's what my Lord Collins was putting to a learned friend this morning, and I obviously dealt with it poorly in opening, but the purpose of 737A was to create an income flow. My learned friend accepted this morning. It's under the heading of tax avoidance, where you've got a deemed manufactured dividend, so not a real manufactured dividend, so as to ensure that the person who got the benefit of a capital disposition of his securities should actually be treated as charged to income rather than capital. That's why it's under the heading of tax avoidance. And I'll come back to points, but again, before the Special Commissioner, we refer to Hansard, and it's clear in Hansard, as far as 730A is concerned, is that one of the reasons for its introduction was to create more tax. I mean, the Financial Secretary to the Treasury positively said that. But just looking at the terms of the provisions, therefore, pre-1996, 737A worked perfectly well because the person in the position of DCC was taxed on the whole of the coupon received.
Taxed on the whole of...
On the whole of the coupon received, my lord, pre-1996. And the purpose, therefore, of the debit created by 737A was to mirror the taxation of the whole of that coupon. I accept that.
But wasn't there also a capital loss on the resale?
In certain circumstances, there might, my lord, but it depends on the character of the person who's reselling, if he's an investor or a trader. Yes. And the point I was making in opening about these things is that more often than not, you've got on one side an investor and on one side a trader. What the revenue are actually trying to do here, and why it is under the heading of tax avoidance, is to make sure that whether you're an investor or a trader, there are income flows from these transactions and not capital flows. I mean, that is a clear fundamental purpose of all of those provisions. But pre-1996, 737A worked because the debit was the debit for the full amount of the coupon, and the full amount of the coupon was taxable on the person in the position of DCC had the transactions been undertaken pre-1996. And the problem is that post-1996, the draftsman has simply drafted into the Finance Act 1996 in Section 97 the consequences of the 737A regime without taking on board the fact that post-1996 the coupon is only taxed on an accruals basis and not on a receipts basis. And that's the defect in the drafting. I mean, we don't run away from that. But what we do say is that it's manifestly clear. I mean, he's got it wrong in a sense, but it's manifestly clear what he was actually trying to do. And what he's trying to do, for better or for worse, is what he's done. And what he's done is given a debit equal to the full amount of the coupon, deemed interest of 28.8 million. Now, I'll come back to this in a moment, but that deemed interest, for the purposes of Section 84, has to be, in my respectful submission, 28.8 million, because the only person paying that interest is DCC. There is no other person who is obliged to pay that deemed fictional interest. And therefore, if you're talking about an accruals basis of accounting, the only person to whom that payment of 28.8 million interest can accrue to is DCC. That's the situation as far as the debit is concerned. As far as the ownership of the gilts is concerned, per contra, the gilts have a 6-month interest period. For 18.5 days of that period, they are held by DCC. Therefore, on an accruals basis, as Mr. Holgate correctly says, you could only accrue to DCC a maximum of 2.9, being the ratio of 18.5 days to 182.5 days, and you accrue to X-Bank the 164 days of interest, because X-Bank is the holder of the gilts for the remainder of that period. But one has to compare that situation, and that's the problem of the legislation. One compares that situation to the situation of the debit, where the only person paying the interest, the only debtor, the only borrower under the deemed fictional statutory relationship is DCC. So the statute has created an obligation, recognised by the statute, of paying 28.8 million. It's all paid by DCC. DCC is the only party to that particular loan relationship. It is a party under which it is a debtor, and therefore the whole of that debit has to accrue to DCC. And that, with respect, probably better than I've just expressed it, is what was accepted by Lord Justice Moses in this case at paragraph 57. Sorry, 51. This is a direct and complete answer to the submission that my learned friend Mr. Furness has made this morning on his alternative argument. You can see it's the same argument because it's set out in paragraph 50 of the Learned Lord Justice's judgment. And I propose for the moment, but it is the same argument, to just perhaps remind your Lordships of the answer that Lord Justice Moses gives in paragraph 51, because we adopt this gratefully. It is clear and concise. He says the answer to that submission lies in the underlying rationale of the accruals basis of accounting. In relation to the interest on the gilts, other persons would have been accruing interest in respective periods outside DCC's ownership of the gilts, whilst they themselves were parties to the loan relationships represented by the gilts. Conversely, the deemed expense incurred as a result of the deemed manufactured payments could only be incurred by DCC and thus only accrued to DCC. And that's the essential point. the deemed manufactured interest is not, as the judge put it, notionally payable in respect of any period other than the period of the repo, the period when DCC was in a deemed loan relationship with X Bank. So far, every judge has accepted that analysis, but I think that's the most succinct way in which it's put. But he also refers to Mr. Justice Norris on the same basis. Lord Justice Reimer agrees with that part of Lord Justice Moses' reasoning, and as I read it, I can't see anything in Lord Justice Ricks's judgment to the contrary, because he says you've got to bring in a credit of 28.8 in respect of the gilts, and that must therefore presuppose that he is accepting that there is a debit of 28.8, or on the same line of reasoning.
Where do you find Lord Justice Reimer agreeing with what is said in paragraph 51?
He doesn't specifically say that, but he does say that he says in paragraph 83, at the end of paragraph 83, Mr. Furness sought to deploy this with the view to supporting an argument that the amount of the credit interest on the gilt relation that must be brought into account is 28.8 million. I said that it is 2.9. It is arrived at those two figures, a debit of 28.8 million and a credit of 2.9 million, that creates a problem. So he's proceeding, as I read it, on the basis of accepting that there is a debit of 28.8. And what he's disagreeing with is the latter part of Lord Justice Moses' judgment, where he says that you've got to increase the credit. Yes, it's paragraph 80, I'm sorry. Thanks. Paragraph 80
I see, yes.
yeah, there is no dispute that under 730A2A of the income, DCC is a deemed loan relationship under which it creates a notional payment of 1.8 million. That must be brought into account. I also agree with Mr. Justice Norris and Lord Justice Moses. The deemed manufactured interest debit required to be brought into account under section 84(1) in respect to the deemed loan relationship is 28.8 million. I'm sorry, Lord, I couldn't find it very quickly. I knew he was saying it somewhere. But that tangentially, I mean, that obviously goes to the heart of my learned friend's alternative submissions, and perhaps I just finish as far as that's concerned. We simply say this, and I give your lordships the paragraph numbers in a moment, but we simply say that it's plain that the only relevant thing to look at for the purpose of section 84, as far as the debit is concerned, is the deemed fiction created by section 97(2)A. It's a point which I made in opening, but probably not as well as I might, I don't know. But it's to contrast the language in section 97 between subsection 4 and subsection 2. If one looks at section 97, subsection 1 says this section applies where, and then subsection 4 says, where section 737A has effect in relation to a transaction related to an asset representing a loan relationship, so as for the purpose of Schedule 23 to that Act, to deem there to have been a payment representative interest under that relationship, this section shall apply, as it would have applied if such a representative payment had in fact been made. So in terms of statutory deeming, that deeming is only for the purposes of section 97. That is therefore for the purposes of getting you into section 97(2), and section 97(2) then says, in relation to that company, the manufactured interest shall be treated for the purpose of this chapter, as if it were interest under a loan relationship to which the company is a party. So when one comes to look at an application of the accruals basis under section 84, all that you're actually deemed to know on the facts of this case is that there is interest of 28.8 million under a loan relationship to which DCC is the debtor paying party. And therefore it follows from the point I've made just now by reference to Lord Justice Moses in paragraph 57, that in those circumstances, since there can't be anybody else who can accrue such interest, then the whole of that interest has to be accrued as a payment by DCC. My reception is that shortly disposes of the alternative argument.
So you're drawing our attention, I suppose, to 97(1)(2)(a) at the end, to which the company is a party.
That's right, yeah.
And that's all you've got in the package, you say.
That's right. I mean, your Lordship made the point to my learned friend, but 97(1) applies to both parties, to the receiver and the payer. And therefore, when one is applying 97(2)(a), that applies to the person who is deemed to be making the payment, and that is DCC. So 97(1)(a), it's probably best looking at it on the basis of the paper we handed in, actually, because we actually interpolated with the appropriate parties. So if one looks at our paper 97,
Yes.
97(1)(a), this section applies where any amount, 28.8 million, is payable by DCC under any contract, and that amount falls to be treated as representative interest. So it's an amount payable by DCC, and then in relation to that company, DCC, the manufactured interest shall be treated with the purpose of this chapter as if it were interest under a loan relationship to which DCC is a party. So it's treated as paid by DCC, and it's treated as paid by DCC under a loan relationship to which DCC, is a party. Nobody else is a party to that loan relationship. So there can't be anybody else who can accrue any part of the 28.8 million other than DCC. And on my learned friend's alternative argument, one would end up with the remarkable position that Parliament has deemed a payment of 28.8 million, which on an accruals basis can give rise to an accruer of only part of that payment, and the rest of that payment can't accrue to anybody at all. It's something that's simply gone into the ether, just disappeared. And that cannot be complying with the statutory purpose derived from the terminology of the provision. Well, I've diverted somewhat in dealing with my learned friend's alternative argument there, but I hope that's helpful. I wanted to go back to the points he was making yesterday by reference to his primary argument.
Yes, very well.
And the point I had been starting with was that his primary argument at the end of the day is not recognising what one's required to do by the statute, the three loan relationships, and then applying the accruals basis to each of them, and then coming to an aggregate. And what he does, in my respectful submission, is to say that in aggregating, what you actually do is you forget about those three loan relationships and you substitute the accounting treatment in the accounts of the actual real underlying transaction. And I say that's simply impermissible, and that's not paying attention to the statutory fictions which Parliament in its wisdom has determined to create for taxing these situations. And that was my second main point. And if I could follow on from that, I'll just refer to Mr. Holgate. He gave evidence as to the application of the accruals method of accounting required to be applied to the three identified loan relationships. And my learning friend says, Mr. Holgate made a lot of assumptions. You can see the assumptions that Mr. Holgate made because he had to determine what loan relationships he would have to look at. And the assumptions he made are, in our respectful submission, the assumptions that do actually, I wouldn't call them assumptions, I'd call them the correct construction of the statutory provisions. Because you'll see if one looks at his report, I mean, it might be worthwhile just to make this point. It's in Appendix Part 2. And his report starts at page 205. And it's in a number of compartments, his report. And sections 4 and 5 deal with the accounting in the statutory accounts. Section 6, then, sets out his understanding of the legislative assumptions. This is page 225 of his report. The heading, section 6, my understanding of the legislative assumptions. And he says that, I'm obviously not a lawyer, but if I'm going to answer these questions, I've got to work out what I've actually got to look at, what kind of loan relationship I've got to look at. And he sets those out. And then one will see on page 227, under the heading of Section 84 of Finance Act 1996, in paragraph 15, you'll see in 610 he's talking about the legal holding of the gilts. So that's the loan relationship that he's looking at there. And he then refers to Scenario 1 and Scenario 2. We argued for Scenario 1 before the Special Commissioner and Mr. Justice Norris and abandoned that in the light of Mr. Justice Norris's judgment. So it's only Scenario 2 which is relevant. And his Scenario 2 is simply that I'm looking at a holding of the gilts for the period of the repo, here 18.5 days, but I disregard any profit from the purchase or sale because that's what I'm told to disregard by paragraph 15. So that's his Scenario 2. And then over the page, you'll see in 229, he recognises the deemed fictional loan relationship under Section 97, and then the deemed fictional loan relationship under Section 730A. And you can see his assumptions at 618 and 621, and they accord with my respectful submission with what the statutory provisions are achieving, what they say. And then he goes on in 7 to deal with the exercise posed by Section 84. So having identified those three loan relationships, he then applies to each of them an authorised accruals basis of accounting. And just to deal with one point that my learned friend made yesterday, Mr. Holgate is a very eminent accountant. He is not here talking about anything other than normal accounting practice. And it would be daft to think that he would be talking about anything other than normal accounting practice, GAAP. I mean, he is the technical partner of one of the 4 largest firms in the country. So he's then applying authorised accounting methods to each of those 3 loan relationships. And you'll then see on page 234, looking at the position of DCC, he sets out the Scenario 1, which I say we no longer rely on. And then he sets out Scenario 2 on page 235 and 236. And this is the critical material. And you'll see in paragraph 715, he says, it's assumed that DCC has invested in the gilts on the date of the sale and disposed of its investment on the date of the repurchase through the transaction with Ulster Bank. However, the debits and credits arising in respect of the transaction with Ulster Bank, the sale and repurchase are ignored, which just leaves the coupon receipt on the gilts to account for. Hence, DCC has a loan relationship with the government in respect of its investments in gilts, but no related transaction for the purpose of Section 84. That's our first loan relationship. And that's the one on which the primary argument is all about whether the right answer, applying Section 84, is 2.90 or, as the revenue contained, 28.8. Then he says in 716, and that's his first scenario point, so I'll leave that, but then 717 he says, alternatively, if one assumes that we ignore the debits and credits arising on the acquisition and disposal of the gilts with Ulster Bank, that it's still necessary to account for the legal ownership of the gilts, being the loan relationship, then the position is as follows. So, in my respectful submission, that may have been his assumption, as he puts it, but that is a clearly correct construction of what we are required to do by force of the statute. And 718 then says, as DCC did not acquire and sell the gilts with the government, there are no gains and losses on disposal of the gilts taken into account under Section 84 in respect of DCC's direct relationship with the government. However, DCC held the gilts at the coupon date and so was entitled to receive an interest payment from the government in respect of its investment. From an accounting perspective, applying the accruals basis as defined in FRS 18, paragraph 27, it is appropriate to bring into account the interest accruing on the gilts only in respect of the period those gilts are held by DCC, that is the proportion of the interest received by DCC. This is because any other party holding the gilts before and after the term of the repo transaction will expect to be compensated by receiving the proportion of the coupon relating to their period of ownership of the gilts. Therefore, under this assumption, in my opinion, the sum which fairly represents the interest arising on the gilts held by DCC, ignoring any purchase and sale proceeds, is the accrued portion of the coupon for the period of the repo transaction. In accordance with an accruals basis of accounting, it could be no more. Specifically, DCC could not recognise the receipt of the full interest coupon unless the gilts had been held for the full period in which the coupon remains.
Well, we did have the benefit of looking at all of this on Tuesday, I
My
think.
lord, yes. But all I'm saying is that that is unchallenged evidence as far as the gilts is concerned. And that clearly establishes that you cannot bring in, so as to comply with an accruals basis, 28.8 million. And he deals with the debit under 737A and section 97. And it's really 723. And again, one would say that what has been criticised as his assumptions are correct assumptions to be derived from the construction of the statute. In 723, he says, however, if there is a legislative need to determine the debits to be brought into account on an accruals basis that fairly represents the loan relationship, then I would understand the legislation may be making an assumption that the deemed interest which is to be paid by DCC under a loan relationship to which DCC is a party was payable in respect of a period for which DCC was a party to that loan relationship. If that is the case, then from an accounting perspective, a debit for the whole amount relating to that period should be recognised in respect of that accrued interest payable. And I mean, that again, as I say, it is unchallenged evidence in applying an accruals basis to the debit. And the only other basis on the statute of looking at the debit would be to say that you don't actually need to go off to section 84 at all. Because if one looks at, for example, section 97.3, it is plain that 97 is recognising that there is a debit to be brought into account by the force of section 97. 97.3 says, any question whether debits or credits falling to be brought into account in the case of any company by virtue of this section are to be brought into account under section 82.2 above, that's trading or non-trading, to be treated as non-trading debits and non-trading credits, shall be determined according to the extent to which the manufactured interest is paid for the purpose of a trade carried on by the company or is received in the course of activities forming an integral part of such trade. And you only actually get to section 82 after you've done your section 84 computation. So that there is at least an implication there in section 97.3 that the draftsman is proceeding on the basis that the debit or credit in 97.2 will be one that is one recognised for the purposes of the chapter. And in effect, he bypasses section 84.
Well, where do we go from here then?
Well, just one final point on Mr. Holgate.
Yes.
That is, I'm not going back to his report or anything like that, but if one looks at his report, if one looks across his own, it was never suggested to him in cross-examination that having gone through this process of identifying 3 loan relationships and coming up with the figures, that as a matter of accounting, he should then look at them together and come to a result which is equal to the result in the statutory accounts. No argument of any such kind was ever put to him. And he's the only accounting witness, the only accounting evidence on which the case proceeds. And as I said in opening, just repeat it very briefly, fairly represents, or sums which fairly represents, in my respectful submission, in the context of Section 84, represent the aggregate of the accounting for the 3 loan relationships, but to be determined by the accountants, to be determined as a matter of accounting. That, as I read in Section 84, is plainly what is required. So you've got to find the sums, and you've got to find that in accordance with an authorised accruals basis, the sums fairly represent the interest. And it therefore seems to me plain from the language that that is something for the accountants, and not with the greatest of respect for the courts, and unless there is something in the statute that says otherwise. In my respectful submission, there isn't. So therefore, the process is an accountancy process, and that in a sense is at the heart of this case. And I know, looking at what the Chartered Institute said, they didn't actually say very much in this particular case, but one knows the real worry about this case is that the computational provisions in Section 84, if they don't bring in accounting, that will lead to an enormous amount of uncertainty in the tax world, because people would not be able to self-assess themselves correctly in accordance with applying accounting principles to the statutory loan relationships which are recognised by the legislation. My next point is perhaps doesn't go to the heart of it, perhaps it's the last one, but my learned friend spent some time yesterday on the position of X-Bank. Could I just clear up what is our position, because he didn't quite represent our position correctly. As far as X-Bank is concerned, what would be the position of X-Bank? Section 97(2)(b) applies to X-Bank. So that recognises that X-Bank receives a payment of cash on its holding of gilts of £28.8 million. That's what Section 97(2)(b) does. And that represents the interest on the gilts. Now, all that achieves is simply deeming X-Bank to be in a position whereby it received a cash payment of a coupon of £28.8 million, but its taxation, assuming it to be UK resident, must proceed on an accruals basis. And therefore, even though it's deemed to have received a cash payment of £28.8 million, it only brings into account an accrual for the period equal to the number of days during which it held those gilts. And that's 164 days, and therefore the correct figure is 25.9 million in respect of the gilts. And if one's concerned with symmetry, the only significance of that point is to make the symmetry point that that is the correspondence to the 2.9 million that is brought into account by DCC. So as far as our submissions are concerned, and an accruals basis is concerned, they are symmetrical. And that brings me on to the next point, that my learned friend sought to respond to our argument in paragraph 146.2 of our case. 146.2 is where we say the effect of Lord Justice Moses' judgment is that for a period of interest accrual of 6 months, whereby only 28.8 million of interest can accrue, he's actually brought into account accruals of 28.8 million plus 25.9 million. Now that's the point that we make in our case at paragraph 46.2. My learned friend, in response to that, I say he didn't really quite follow it, but his main point seemed to be that he says that the flaw was that there was no such thing as a taxable coupon.
Just on, sorry to interrupt you, just on the figures, there are a couple of small misprints in that subparagraph, aren't there? Do you see that the first reference to 25.9 is right, but then 2 lines down it should again be 25.9,
Yes.
and the total should be 54.7, I think.
We've got the arithmetic wrong, but I'm perfectly happy to accept that from you, Lordship.
Well,
Sorry,
it's,
yes.
it's simply a typo.
Yeah.
Anyway, the attack was on
Yes.
the last sentence, I think, wasn't it? The reference to taxation.
Yes, that's right, my lord, yes. And the learned friend says, well, coupons aren't taxed. Now, coupons were taxed pre-1996, but leaving that aside, it's not the question, what we're concentrating on is the accrual. We're not looking at the taxation of the coupon, we're looking at the taxation of the interest in respect of the holding of the gilts. And what we are saying is that over a period of 6 months, in respect of these gilts, there is only a total of 28.8 million that could accrue. The consequence of Lord Justice Moses' decision, his judgment, is that those 2 amounts accrue, 28 million plus 25.9 million. And that cannot be an accrual in respect of 28.8 million of interest. And that demonstrates that what is actually done is to invent an additional sum. And so far, I mean, we've made 3 arguments as far as Lord Justice Moses' judgment is concerned. The first was the textual one, which, I mean, is best expressed perhaps by Lord Justice Reimer in the passage we've quoted. The first is the point that I've made by reference to the terminology of section 97.2, and that's the deemed fiction, and you're not allowed to go back to the ingredients that got you there, as it were, because they're not part of the statutory fiction applying for the purposes of section 84. And this is the third one. So those are the 3 arguments that are responsive to Lord Justice Moses. The next point was then there was the point about the 2.9 million accruer. I've shown you what Mr. Holgate said. I don't think I can say anything more about that. I mean, as far as an accruals basis is concerned, his evidence is clear. We've made the point in paragraph 143 of our case that in accordance with an accruals basis, you can either get 2.9 or 0. What you manifestly cannot get to is 28.8. This is tangential, but it might help, and I'll deal with it very briefly. In answering a question from my Lord Walker, one was concerned with, forgetting repos for a moment, and one was concerned with a disposition of a gilt during a coupon period and what the respective parties would do. And could I just explain what the correct accounting is there? Because there may have been some misconception, I think, in what my learned friend said. Let's assume one's got X bank and it acquires a coupon at the beginning of a period. And let's assume that a month later its accounting year ends. No coupon has been paid or anything of that nature. As a matter of accounting, for that month it will accrue in respect of the interest which is accruing on the holding of the gilts. So on a time basis, let's assume that the gilt carries 12% per annum, it will accrue the equivalent on a simple interest basis of 1% for that 1 month, whether it's received a coupon or not. Let's assume then in January, at the end of January, it sells that gilt. Again, no coupon has been received, to somebody else. And it will sell that gilt for a price. On an accruals basis, it will have accrued 1% for the month of December, 1% for the month of January, so far 2%. When it sells, it will then make a comparison of what it sold for and what it paid. If that gives rise to an amount equal to 2% on its original purchase price, then it will make no adjustment to its accounts. But if it sells for an amount which means that it's accrued too much in respect of the holding of the gilts, or accrued too little, it will adjust for the difference. And that's an accruals basis of accounting, and that's what Mr. Holgate was talking about in his evidence. And one of the difficulties about this legislation, of course, this is what Mr. Holgate was having the difficulty with, is that by force of paragraph 15, you don't actually take account of that latter stage at all, because you're excluding any profits or gains from the related transaction. But as I say, that's a tangential point to the case, but I thought if I just made that point, at least it might clarify what the ordinary position is as a matter of accruals accounting. My next point, and I'll move on quickly, it's simply this. I mean, it's that I've listened very carefully, and I've listened to all cases in all levels of authority, in this case to my learned friend, very carefully as to his argument. But still, with the greatest respect, I cannot see his argument based on the terms of the legislation. I cannot see how one can construe those terms to get either an additional credit from the gilts of 25.9 million, because that is flatly contradicted by the requirements of an authorised method of accounting, or, I mean, conceivably, what he might like, some additional loan relationship, a fourth notional loan relationship, that in effect the whole of his argument is because Parliament has actually given too much of a debit under Section 97, somehow by hook or by crook, you've got to knock that out or produce a figure to counterbalance it. And all I can say is, for the reasons I've been advancing, as a matter of statutory construction, and I'm sure your lordships won't like the result, but as a matter of statutory construction, I submit one's driven to that result, and it really is absolutely impermissible as a matter of construction to get to any other result. And I really have not heard anything yesterday or today or below from the learned friend that is based in the construction of the statutory words to get to the result that he desires.
Well, that really focuses the central issue, doesn't it?
Yes. And my lord, it's illustrated in a sense by the fact that he doesn't really mind how one gets there. I mean, it can either be a credit of 28.8 or a credit of 2.9, but provided the two things knock each other out, whatever the figure is, doesn't matter. And even in the last resort, let's forget about all the loan relationships and go back to the Special Commissioner who just relied on the statutory economic result in the statutory accounts. But none of that is based with respect on the statutory language, and the primary argument flatly contradicts the statutory language. It can't live with an accruals basis of accounting, and therefore the result you end up with is one which he has to rely for that argument under Section 84. And you end up with a result which is flatly in contradiction with the requirement of the statute on his primary argument.
Well, I think we are entering the area of repetition for
Well,
understandable
I'm sorry,
reasons,
yes,
but
yes.
I think we absolutely have your point.
And I've made my points on Section 97, which is the alternative argument. that under Section 97, the only debit you can actually get to is 28.8. I was just trying to summarise that. Mr. Justice Norris, well, he dealt with looking at his judgment yesterday, and in particular paragraph 55. We're quite happy with Mr. Justice Norris's judgment. And just again, for a point of clarification, when Mr. Justice Norris was talking about profits in paragraph 55, he was talking about the profits in the statutory accounts. And I think this goes to the heart of my learned friend's primary argument, and this is where Mr. Justice Norris rejects it. Paragraph 55, he's referred to the together argument put forward by my learned friend. And he says at 55, I do not agree. What Section 84 requires is that the debits and credits to be brought into account in respect of the loan relationships are those which are in accordance with an authorised accounting method. And further, that the debits and credits so identified shall, when taken together, fairly represent the gains arising from the loan relationships. The section does not say that the debits and credits must fairly represent the profits. And he's there talking, and this, as I understand my learned friend's argument today, is his primary argument. But he's saying, as a matter of aggregation, you've got to get back to the profits in the statutory accounts. And that's what Mr. Justice Norris is rejecting. And one can realise that because of his use of the term profits, because as he rightly understands, under the loan relationships, we're only concerned with interest. We're not concerned with profits. We're concerned with interest. Your Lordships will all remember that under Section 84, there is a clear dichotomy between profits and gains in the first subsection, subparagraph, and then interest in the second one. They're clearly distinguished. And as far as the loan relationships are concerned, that we are concerned with, we've actually got, by force of statute, just 3 lots of interest. And so Mr. Justice Norris there is saying the section does not say that the debits and credits must fairly represent the profits. It must fairly represent all the interest on the loan relationships. And does not say that you can create debits or credits such as would not normally be made in accordance with an authorised accounting method in order to produce such a fair representation. And he makes again a valid point at the end of that paragraph. Mr. Holgate's evidence did not disclose any authorised accounting method by which Section 28.8 million could be entered as a credit in respect of the receipt of the coupon. The accruals method required a credit of 2.9 million, the income accruing during the period of ownership. So as we say, there is no valid criticism of Mr. Justice Norris's judgment, nor indeed of Lord Justice Rymer's judgment, and Lord Justice Rymer agreed with Mr. Justice Norris. And just, I've made my main points as far as Lord Justice Moses' judgment is concerned. My learned friend yesterday was using Lord Justice Moses' terminology of the purpose of the interest debit being to cancel out the receipt. And I can understand that use, I mean, as far as the original function of Section 97 was concerned. But as far as the terminology is concerned, it's important to take on board what we've actually got. And what we've actually got is in Section 97.1 terminology which says it represents an amount. I didn't talk about cancelling out. But my point, and I've already made this, but the answer to it is the first point we make at paragraph 146.1 of our written case, and that is that the only fact that one's required to know or allowed to know for applying the Section 84 exercise is that one's got a deemed payment by DCC of 28.8 million on a loan relationship to which DCC is the only debtor party. And that's by force of the deeming in Section 97.2. And that minus position on its own knocks out the cancelling argument, but the other two arguments as well. And also, the only other point, yes, when Lord Collins asked about the purpose of 730A and 737A and 97, I attempted, but obviously not particularly well, to deal with that in opening. Could I just attempt very shortly to deal with it now, as to the purpose of the two provisions? I mean, as far as 730A is concerned, I'd illustrate it by giving a simple example. An investor enters into a repo as a buyer. He buys a security for £100 and sells it back for £105. So he makes a capital gain. That is not taxed as income. The revenue don't like that consequence. Therefore, they enact 730A so as to convert that gain into income. That's the purpose of 730A, and as I said, if I were to read Hansard about it, its implementation, it basically proceeds on the basis that if they didn't implement it, there would be a loss of tax, which in government speak terms means that on the present basis of the law, we're not collecting as much tax as we would like to collect from the transaction. The purpose of 737A and Section 97, which is derived from it, simply can be illustrated by another example. An investor sells some shares for £105 in a repo, with the buyer being a trader receiving the income coupon. And therefore, it's a situation where the seller has avoided receiving the coupon and has actually made a capital gain instead. And the purpose, and I think my learned friend Mr. Furness effectively was accepting this morning, the purpose, therefore, of 737A is to convert that capital gain into an income interest flow. So that's the purpose of 737A. And Section 97 has simply adopted the consequences of it, and I accept, without taking on board the fact that the coupon post-1996 is taxable on an accruals basis, not on a receipts basis. But that is not to deny that Parliament actually has enacted what it has enacted. And that explains why those provisions are under the heading anti-avoidance. The repo provisions are under that heading. I mean, also, I don't think there's actually anything more I can say, unless obviously your lordships want to put anything more to me.
No, I don't think so. Thank you very much, Mr. Gardner.
Well, I'm obliged.
Well, we're extremely grateful to all counsel for their assistance, both in writing and orally, over the past 2 or 3 days. We will take time to consider our decision.
You're obliged.